Hi, I'm Emma Jane Taylor Moran and I'm an employment lawyer at Rebel Law. I'm here to talk to you about redundancy. So, your employer has sent you an at risk of redundancy letter, or they should have. This kickstarts the redundancy process. You're quite understandably worried and scared about losing a job. Employers often try and rush things and conclude the process within 2 weeks. Public sector employers take a lot longer. Your employer should invite you to a redundancy consultation meeting. At the meeting, you should ask them to justify their business decision to reduce headcount or restructure your team. It's good if you and colleagues work together on this. A proper consultation should take as long as it needs, be genuine and meaningful, and a two-way process. The employer should explain their business rationale, the selection criteria, and what they're going to do to try and avoid making redundancies. That may include a recruitment freeze, letting agency staff go, job sharing, reducing hours or pay. You should bring your questions and suggestions. Be creative and see how they respond. If you are to be selected for redundancy, this should be based on fair and objective selection criteria, like your disciplinary record, for instance, not whether your colleagues like you or not. Things like maternity or disability related absence should be ignored if the employer scores people on attendance. Once it's confirmed that your role is redundant, then your employer should look for alternative roles within the business and in group companies. Employers often do this at the same time as the consultation and they muddle up the processes, leaving them open to potential challenge. Your employer should hold at least 2 consultation meetings, ideally more. And they shouldn't really count the first and last ones as consultations if they were to initially inform you about the potential redundancy situation and then to inform you that you've been made redundant at the end of the process. This is another mistake most employers make. And I'm sorry to say that 9 times out of 10, the outcome will be that you will be dismissed for redundancy. This is usually because employers decide at the start of the process, not the end, as to which staff will go. This is another mistake. And any evidence you can point to show this will help you if you decide to challenge the decision. Also, it shouldn't be a personal decision. It should be neutral and based on a reduced need for someone to do your role or because an office is closing. If you think you've been selected for a reason personal to you, not about your role, for example, because of your age, sex, disability, or race, or because you complained about something, or if you think your employer hasn't followed a fair process, then get some legal advice to explore your options. If you have good reason to believe your dismissal is unfair or discriminatory, then there are several things you can do. You can raise a grievance, you can appeal your dismissal, you can approach your employer on a without prejudice basis, that means off the record, to talk about settling your potential claims. This is best done with the help of a lawyer who can advise you properly on your approach and the merits and value of your potential claims. Otherwise, you're just going in blind. Give us a shout and we will chat through how we can help. Don't worry, this initial call is free and you don't have to end up in a tribunal just by talking to us. We are negotiating superheroes and most of our cases settle out of court. Here are our contact details and we'd love to hear from you. And don't worry, it's going to be okay.